The Sixth Amendment also contains an arraignment clause, which mandates that the accused have some notion and be read in detail the nature and scope of the allegation of the crime, such that they have a full and fair understanding at the inception of a criminal charge of what the accusation is against them. The reason why that's critical is because that was a fundamental change from the administration of justice under the empire, and certainly the way it was in Europe, places, the monarchy in France, where charges were made, people were arrested and locked away to die in prison. If anyone's ever read or seen any of the Count of Monte Cristo movies, that's exactly what that book is premised about, and exactly what that author was writing against was the imposition of secret charges, secret tribunals, prisons where people rotted away. Another one of the critical rights in the Sixth Amendment is the right to confrontation. And what that means is that the accused will have the right to cross-examine the witnesses against him or her, and thereby through that jury system, or in modern cases, the right to a trial by jury may be waived, and sometimes that's the right thing to do, but the right to confront the witnesses against you, the right to cross-examine those witnesses and to determine the veracity of those accusations. One of the reasons for the confrontation clause is because out-of-court statements under imperial rule were admitted into evidence frequently, and they were used to uphold convictions, and these were statements by others who were not present in the courtroom, and the accused could not judge, nor could a jury, or back then under the empire, could a citizen, if they could afford an attorney, they couldn't make arguments about the unbelievability of that person's testimony, because the only thing that was there for the court to weigh was a piece of paper with a statement on it that says, "It is because I say." And you can't determine if somebody's being forthright and truthful, and you certainly can't explore any weaknesses in their story, because you've just got a cold sheet of paper that is making an accusation or supporting an accusation, and it deprived people of that fundamental right to confront those witnesses against them. Again, back to the need for the publicness. The public nature of our justice system now is to force those who are making accusations to come to trial to prove them. There's also a compulsory process protection in the Sixth Amendment, and what's important about that is, again, just focusing on how it applies to criminal proceedings, and that's what the Sixth Amendment applies to. The accused has the right to find witnesses in their favor, and more importantly, to subpoena those. That's what compulsory process means, is to have a document that is a command that they appear in court and offer testimony. And that testimony presumptively would be favorable, but people may not want to come. They may be related to the accusing witnesses. There may be political reasons that they don't want to get involved, or they just have, like most Americans, a fear of public speaking, and they will avoid public speaking at all costs. And that's why the Founding Fathers guaranteed the right to compulsory process to bring favorable witnesses to court for the accused.